Okay, a good afternoon and a very warm welcome to Jones Chase's webinar on the new Employment Rights Act 2025. For those of you that are new to our webinars, we are, of course, a firm of specialist employment lawyers, and we act for a number of companies, from PLCs all the way through to startups, and for some fantastic individuals as well. And we're very proud to say that we have a very high success rate of looking after those that we represent. And thanks so much for joining us today. In terms of format for the webinar, if you want to ask us some questions, which we will probably leave to the end, please use the Q&A box. If you want to do this anonymously, please press the button to do so anonymously. If you want the rest of the attendees to see what you're saying, then there should be a drop-down box to say that your question can be seen by all panelists and attendees, and that can be quite useful to keep the chat flowing. If you don't mind your name being displayed on the webinar, you can use the chat box, which we'll be keeping an eye on too. And I should add that we are recording the webinar to allow those that couldn't make it at this time today to watch the webinar later on. So please bear this in mind if you're asking questions and you want to participate on an anonymous basis. I should point out that the points that we're covering today are not formal legal advice, and so much depends on the evolving law and the individual circumstances of any case. So please do bear that in mind. I should also add that we are do not rely upon this webinar for legal advice as well. And if you do need any help, just definitely drop us a line. We'd be very happy to help you. A little bit more housekeeping. The information that we're covering on this webinar is accurate as of 12 o'clock on the 18th of March 2026. And in the world of employment law, things are always changing very, very quickly. Please do drop us a line if you have any further questions. And lastly, for the introduction, we do like helping people. And if you find our content or advice useful, please feel free to pass that on to other people. Okay. So I'm just going to start the webinar with a very sort of brief overview of the Employment Rights Act 2025. And of course, after 12 months after being introduced to Parliament and after some ping pong back and forth, it finally received royal assent on the 18th of December. It does represent the most significant overhaul of worker protections in a generation. It fundamentally increases obligations on employers whilst at the same time increases the rights of employees. And the Act is pretty gigantic. It introduces a considerable number of legal changes and just far too many for us to cover in just one single webinar. So what I will do now is very quickly run through what I think the most fundamental changes are by way of a top 10 list, and with a particular focus on those changes that are coming into effect on the 6th of April. I should add as well, if you want more information by way of an overview, if you look at our website, joneschase.com, we've got a downloadable summary guide in the downloads section. It should be quite easy to find. And in addition, we've got a more comprehensive guide in the news and events section. So have a look at joneschase.com, the news and events section and the download section. Okay. Just moving quickly on with the top 10 list. A lot of changes come into effect on the 6th of April 2026, so next month. The first one being that paternity leave will become a day one right. Okay, so employees will no longer need 26 weeks of service to qualify for paternity leave. Please note that this operates differently to statutory paternity pay, for which people would still need to get 26 weeks service to qualify for statutory paternity pay. The second change is that ordinary or unpaid parental leave also becomes a day one right on the 6th of April. And employees will no longer need 1 year service to qualify for unpaid parental leave. Both of these changes may require staff handbooks and policies to be updated, so please drop us a line if you need any help with that. Third change, by way of a quick overview, is that the restriction on taking paternity leave after shared parental leave will be removed. Number 4 from the top 10, there will be changes to the statutory sick pay regime. First of all, SSP will become a day one right, and the 3-day waiting period where ordinarily no pay is received for the first 3 days of sick leave, that's been removed, so pay will be payable from day one. Also with statutory sick pay, the lower earnings limit, which is currently £125 a week, is being removed. And so that means that a lot of part-time workers will be brought into scope for the SSP regime. Okay. And again, this too may require contracts and staff handbooks policies to be updated. To drop us a line if you need any help. Number 5, pretty big one for collective redundancies. The penalty for getting a wrong protective award is being doubled. The the amount of it's been doubled from 90 days gross pay to 180 days gross pay, which is pretty significant. We also have an amendment on the 6th of April coming in relation to whistleblowing. And if you complain about sexual harassment, that will be a qualifying disclosure under whistleblowing law. For the rest of them, we need to look a little further forward. So 2027, there will be changes to the law relating to 0 hours contracts, okay? The first of which is that workers will gain the right to a contract with guaranteed hours if they work regular hours over a reference period. Also, number 8 on 0 hours contracts, we have the right. The workers will have the right to a paid shift if the shift is cancelled or cut short on little notice. The government's currently consulting on the 0 hours provisions, and we expect more law to come away with regulations in relation to them. 2 more quick changes. There will be a new right to bereavement leave, which will be in addition to the existing right to parental bereavement leave. That's coming in 2027. And lastly, for me, there will be, again, this is subject to future regulations, but there will be a strengthening of dismissal protection for employees doing pregnancy, maternity, adoption, or shared parental leave, or within 6 months of returning to work. Okay. I appreciate that that's a very quick overview, but I wanted to keep the time for the webinar to get into the main issues in more detail with our fantastic speakers here. And of course, there are changes coming for unfair dismissal laws, sexual harassment laws, and fire and Rehire. So that will be dealt with by our fantastic speakers. The first of which is Susanna. So over to you, Susanna, to speak about the new unfair dismissal laws.
Thank you, Dean. Yeah, so I'm going to concentrate on the 2 areas which will come into effect from 1st of January 2027, and that is reducing the qualifying period for unfair dismissal from 24 months to 6 months, and the last-minute decision made by the government to also remove the cap on the compensation for unfair dismissal. Really, I think that hopefully my talk is very practically based, because I think that there are a number of things that need to be addressed in what is a relatively short period of time. So in preparation for this significant change, although we have had changes in length of service before for qualifying, and it has actually for a short period of time was at some point reduced down to 6 months, but then during Blair's government went back up to 1 year. So I guess it might be a moving feast again for us when they've actually realised what the true implication of this decision is going to be. But what is really the first risk point, because getting it wrong is going to be more expensive, and candidates with protected characteristics may challenge recruitment processes more, because we expect employers are going to generally be more highly selective in their recruitment going forward. We know that poor recruitment of candidates can increase the likelihood of increased capability and conduct problems, which often, when they're addressed, escalate because people go off sick with stress at work. And given that we're only going to have that 6-month period, it's highly questionable whether extending probation in this new era that we're going to be entering into will cover a period when someone off sick, where you're going to extend probation because of a period where they've been off sick. So in respect of recruitment, the risk areas we consider are usually around informal recruitment decisions, or more likely rush decisions, where there's unstructured interview processes, there's inadequate record keeping, lack of objective selection criteria, and just insufficient reference checks. And by reference, I don't mean employment reference checks. I mean general checks about all sorts of things. So really, you need to be reviewing your recruitment and your recruitment framework and have that in place by 30th of June 2026. And that should really be focusing on ensuring that all roles, and I suggest this shouldn't be just new roles, but also existing roles, have clear job descriptions and core duties clearly defined with the essential skills and qualifications identified. Testing for skills and experience will now be absolutely critical, as would, I would suggest, profile tests, personality profile testing to ensure correct team fits. You're going to have to be very clear on objective criteria. You need to, and this is really important, have written evidence that reasonable adjustments have been considered for disabled applicants and recruitment processes adjusted appropriately. And then back to normal sort of things, but often get sidelined or don't get followed, using standard interview questions to ensure that same core questions are asked of each candidate. And it'll be really important for you to record, once all interviews are completed, the reasons for selecting that successful candidate. So I think there's a tightening up of your recruitment processes. I think it's going to become even more expensive because clearly there'll be a knock-on effect with recruitment agencies changing their charging terms because they're more likely to find that candidates have their employment terminated within that first 6-month period more readily. Moving on to induction. Now, this is often an area which employers treat as a simple orientation experience or exercise, but I don't think that will be good enough going forward. It's going to now be, induction is now going to be an absolutely critical stage in the employment process because you will need to establish clearly from the get-go what a company's expectations are. It's going to be really important, therefore, that your new candidates, your new employees understand the workplace rules, what the expectations are, and what will happen if they don't follow through in the probation process. So we're saying that there should really be a formal induction procedure if you don't, or process if you don't have one already. And definitely there should be a meeting where a line manager sits down with the new employee and discusses with them what their job responsibilities will be, what the expected performance standards are, what conduct and behavioural expectations are being expected, what their training needs will be, and establishing and recording the review meetings for the ongoing review schedule meetings. And very importantly, explaining what the consequences of failing probation will be. I mean, I would go so far as to say that I would get the employee to sign the meeting notes of that induction meeting with saying something along the lines of, I understand what is expected of me in my role and the performance standards that I need to meet to pass my probation period. And actually, those meetings with senior individuals will become very, very important. And so boards should be considering having that type of meeting with somebody coming into a C-suite or senior leadership role. The induction process should also include, and Harriet's going to probably look at that more with the harassment side of things, but there should be a separate meeting. Often we just say to an employee, these are our policies, you're obliged to read them, and we hope that is sufficient, that they have read them. But I think going forward, it will be incredibly important that you are sitting down with a new employee and explaining to them what your anti-harassment policies are, what the code of practice is, what your attendance requirements are, going through any or summarising any key other policies that you specifically need to bring to their attention, probably setting out what reporting structures are, and again, reinforcing what probation arrangements will be. If we look then at probation, which now we all have and we're all familiar with the process of probation, but the issue that we often see is that actually not a lot happens during probation, whereas I believe this is now going to be a very fundamental and key element for you. So induction and probation, absolutely critical. Probation is obviously going to need to have some scheduled review meetings. And you also need to consider and decide what your probationary periods are going to be. Most people have either 3 months or generally, actually, most people have 6 months. I'm not sure there's any value anymore in having a 6-month probationary period, because if you've got to 6 months and then you decide to terminate, they're going to have acquired unfair dismissal rights. It seems to me that it would be better to have a 3-month probationary review period, a 3-month probationary period, and then you can extend it by up to a further 2 months. You want to get to month 5, and if you're not satisfied that the individual is meeting the standards required, you would then decide to terminate. Moving closer and closer to 6 months, you need to be aware that the 1-week statutory notice principle applies. So in fact, even though you may have pylon clause and think that you can terminate in that week before the 6-month period is reached, that principle will still apply and somebody will have unfair dismissal rights. So in reality, if you're going to terminate because someone isn't meeting the standards required, you really need to make that decision by month 5. So I think a suggested timeline is week 2 check-in, probably a month 2 review, a month 3 review. At month 3, you either decide to terminate or you extend, and then you would have a month 4 and 5 review, or you may simply leave it to a month 5 review. But these are really going to be critical, because in this, if you allow somebody to go beyond the 6 months, or you decide to extend probation beyond the 6 months, you want to be able to demonstrate that the employer, that you identified problems early on, that you have records of their performance or conduct concerns, that you did set improvement targets and objectives. And I think I'm definitely not recommending to anybody that you wait until the end of a 6-month probationary period to raise any of these concerns, or to, as I said before, make the decision to end the employment at that point. The only benefit from my perspective of extending a probationary period beyond 6 months would be perhaps to have that shorter notice period. But I think you would be in real jeopardy if you thought that that would entitle you to perhaps not follow any kind of formal performance management process after 6 months. The risk then of an unfair dismissal claim would be very high. And that's why I get to the 4th point, which is performance management. Managers must start addressing issues about performance really early. And I think it's really important to distinguish between conduct and performance. So capability, I think that, that question is, will they or won't they, or can't they, is the real question. If they're not doing something, then it's likely to be conduct. Whereas if they can't do something, it's potentially likely to be capability. But I just want to reiterate, we see so often that the poor handling of performance quickly escalates matters, because the employee goes off sick with stress at work, and often at that point disabilities may, particularly the hidden type of disabilities such as dyslexia, ADHD, that type of thing, are brought up. Companies need to review and tighten, therefore, their performance management framework, and they need to provide training and invest in training for their line managers. And importantly, you need to give them time to do this properly. So I think, we see a lot of blurring of how performance is managed, where PIPs are used to then dismiss somebody rather than following a proper capability procedure after a PIP is being activated. So really, you should be looking at ensuring that you've got this 3-stage process where you have an informal intervention, a structured improvement plan, so the PIP, and then if the PIP isn't met, entering into a formal capability process. And it's really important in the informal. So this is where I often see that things escalate quickly. So managers are often talking to people about performance, but the employee doesn't understand that that is actually part of the performance management process. So I think it's really important that you're educating people. So the line manager needs to make it clear that when they're talking to somebody on an informal basis, hoping to improve the performance by simply doing that, that they need to understand that it is an informal performance process that they're in, and that if they don't improve, that will escalate to the PIP. And it would be important to keep that recorded. PIPs should be there to support individuals to improve their performance. And I really think that you should look at a typical period of time for a PIP would be somewhere between 4 and 8 weeks. And then, as I said, if somebody doesn't meet their PIP performance requirements, then you move on to the formal capability process. But more so than ever, if we are relying after 6 months on reasons to terminate, and if it's performance, you will have to be able to demonstrate a clear, focused, reasonable performance management process. And as I said, that for us is where we see lots of things falling down. And often it's because people don't have time to do this properly. They don't have the support, they don't have the knowledge. People get promoted into management positions, but they're not provided with the training. And so my recommendation is that there should be a clear focus put into performance management. So those are my key points that I wanted to discuss. But just from my perspective, you need to have a lot of these things starting to be activated from the 1st of July 2026, because anyone you're recruiting from that time, when they get to the 1st of January, will have acquired unfair dismissal rights. You need to support your managers and give them training. And the cap is going to have, the removal of the cap is going to have an impact. It's estimated that they're likely to be an increase of up to 20 to 25% of tribunal claims in 2027. And the knock-on impact for us and you of that is that the litigation now will be very long, which means, and also in a situation where we have employees not being able to secure new employment quickly, we are going to have greater periods of compensation being awarded. And I think ultimately we'll see a lot more senior employees bringing unfair dismissal claims who may have been dissuaded from doing that simply by the cost and the cap. Whereas now, if they have an unlimited cap, they may be more inclined to pursue those claims. So that's all I wanted to say on those matters.
That's great. Thanks, Susanna. And you're exactly right. I think the removal of the cap is going to have a huge impact for high earners, because some of the people that I've spoken to over the years have, when you mentioned the statutory cap, they said, oh, well, it's not really, due to the amount that they earn, it's not really worth them bringing a claim. But that is no longer going to be a thing. So there will be, some pretty expensive litigation and risk there for employers. Absolutely. We did have one. Also, I should say, sorry, for some reason, I lost connectivity, and Zoom decided to kick me out in the middle of whilst you were speaking, Susanna. So it doesn't look like it's disrupted the rest of the webinar. I really apologize for that. I don't know what happened. But anyway, I'm back now. We did have one question from Sarah prior to the webinar going ahead. Which I think, Susanna, you can probably answer this if you haven't already. And Sarah's question was, if the employer probation period is 6 months, will that still be able to be extended? So do you have an answer for that, Susanna?
Yeah, I mean, obviously it can be extended, but I'm not sure why you would. I mean, my recommendation advice is you need to review whether 6 months now is appropriate. because they'll have acquired the unfair dismissal rights. So I think that's a decision for you as an employer, but I would recommend 3 months, as I said, with the right to extend up to 5 months, because after 6 months, you're moving into performance management and following a proper performance capability process rather than relying on probation and on a what might be a more casual probation management process. So I don't know whether the team have any other views, but I think it's dangerous and not worth it anymore.
Yeah, I think you're totally right. Everything needs to be squeezed into the first 6 months. And as you've said, decisions should be made around about month three, I think, to be on the safe side. I think you can usually, as I'll say this, I don't know what other people think, but I think you can usually work out relatively quickly whether someone can do the job or not. I think within the first 3 to 4 months, you should have a good idea. And as just not letting things drift anywhere close to sort of 6 months is absolutely key now. So probation period should be very much more closely policed and managed. And I was going to say this at the end of the webinar, but for all the attendees, Jones Chase is building a pretty comprehensive Employment Rights Act 2025 compliance package. We'll be releasing more information about this by way of email, but we're putting a pretty big package together for our clients to make sure that you're all up to date with the law. And Susanna's got a big hand in that in relation to processes and documents. Dealing with the first 6 months of employment, which you've just mentioned. More details on that to come. Great. I'm just going to move on to Lisa, who's going to speak about the new fire and hire regime. So over to you, Lisa.
Many thanks, Dean. Good afternoon, everyone. So, as Dean mentioned, I'm going to look at updates around fire and rehire practices, which will be implemented in January next year. I think this is another area where we're going to see a massive shift change, and amongst everything else going on, it's easy to miss the significance of this particular reform. Essentially, though, the ability to alter contractual terms is going to become much more difficult, and I expect is something that will create a challenge for most employers at some point. Before I share some practical insights as to how you might go about preparing for these changes, I will set out what the current position is and what the updates will involve for context. So firstly, just to explain what we mean by fire and rehire, this simply refers to where an employee is dismissed and is then re-engaged under a new contract. This term can also refer to a fire and replace situation where an employee is dismissed and replaced by somebody else. For many employers, this strategy would only be used as a final attempt to push through changes to an employee's contract. So where it's not been possible to reach an agreement, as a last resort, employers can give notice on existing terms, offer the new terms that were not agreed in order that they then carry on after the notice period expires. We see this approach adopted in scenarios including where a company wishes to harmonise terms across its business, remove benefits due to financial constraints, or in order to introduce a new pattern of working. From an employee's perspective, they would either have the option to walk away or to agree the changes. And with either outcome, a claim for unfair dismissal is a possibility. In terms of the current position then, although this has been seen as controversial for some time, the practice of fire and rehire can potentially be lawful. An employer would need to provide a business justification for the changes along with a potentially fair reason for dismissal, and this typically would fall under the category of some other substantial reason. A fair process would also need to be followed in the usual way. As things stand, there is reasonable scope for unfair dismissal claims in this area to be defended, and the current statutory cap on compensatory awards also serves to limit any financial impact here. Risks can potentially also be limited currently when this tactic is used for employees without the 2 years service, which is currently required to bring an ordinary unfair dismissal claim. Moving on then to what will be changing. Although there were previous indications that this practice would be banned altogether, this will not be the case. But as I mentioned, the ability to use fire and rehire to change terms will be hugely restricted. So what will actually happen is that a new automatic unfair dismissal category will be introduced. And this means that dismissals which impose certain key contractual terms, known as restricted variations, which I'll come on to, will be automatically unfair. This will be the case if the reason for dismissal is the employee not agreeing to the changes or so that a replacement can be engaged on varied terms in a comparable role. A dismissal being classified in this more onerous way will remove the usual qualifying service requirements and, in practical terms, will give far less room to defend the employer's decision. In fact, the only defence available will be a new financial difficulties exemption. And to qualify for this, employers must prove that they are in severe financial trouble, that the changes are necessary to avoid the company going insolvent, and that no reasonable alternatives exist. Interestingly, there'll be no scope for foresight with this exemption, so the test requires a need to show that costs must be cut now rather than this being envisaged in the future. And I think the common consensus is that as the threshold here for this test will be so high, this defence will be fairly useless in reality. On top of this, even if the financial test can be met, tribunals will still have to assess whether the dismissal was fair in all the circumstances. So this would include looking at things like the reasonableness of the decision, along with whether proper consultations took place and if suitable consideration was offered. So circling back then on the new automatic unfair dismissal category, just to be clear, this will only apply to what will be deemed restricted variations. And these are essentially what we'd all consider to be the key elements of an employee's contractual terms. And they're fairly broad in scope, including things like reductions in pay, changing working hours and pensions, material changes to shift lengths and times, time off rights, including reduction to holiday entitlements, and imposing flexibility clauses allowing changes to be made unilaterally. Importantly, changes to location and job role will not be deemed restricted variations. We're also expecting that changes to expenses, benefits in kind, along with other minor changes to shift patterns may be excluded from the definition. This is, however, subject to a further government consultation, which closes shortly on the 1st of April. Although these exempt terms will not be automatically unfair, they will still need to be fully justified and subject to a meaningful consultation process before they're varied. Variations to non-contractual elements will still be allowed, so it should be possible, for instance, to withdraw a fully discretionary bonus scheme. Further changes within the scope of agreed and existing flexibility clauses will be okay. Employers will also still be permitted to hire new recruits on different terms and make pay rises conditional on employees agreeing to the changes. So just to summarise, when making variations, once these reforms have been implemented, the stages employers will need to think about will be, firstly, is the intended change a restricted variation? Can it be agreed? And if not, and a dismissal is required as a last resort, can the financial difficulties exemption be relied upon? And even if this is the case, would the dismissal be fair in all the circumstances? So now moving on to thinking about the practical implications of all these changes. So most importantly, there's clearly going to be an increased financial risk in terms of potential penalties that can be awarded for successful claims in this area, as these changes will take effect at the same time as the enhanced protections for unfair dismissal claims. There will be the combined impact of no statutory cap applying to compensatory awards, a reduced period of qualifying service for ordinary unfair dismissal, along with further scope for automatic unfair dismissal claims. On top of this, an uplift of up to 25% will remain in place for failing to follow the code of practice on fire and rehire. And additionally, depending on the circumstances, if there's a failure to comply with collective consultation obligations, each affected employee could be entitled to an increased protective award of up to 180 days grace pay. So apart from penalties, I think there will be a shifting bargaining position of parties in favour of employees. Currently, employees may be more inclined to agree to variations if they know that one outcome is for them to be rehired on new terms. But going forward, I think employees are more likely to back down if the changes cannot be agreed. Otherwise, employers are likely to take a cautious approach more generally, particularly when it comes to engagement, by reducing benefits and committing to less in contracts. Similarly, there's likely going to be an increased use of non-contractual policies and variation clauses to reduce risk levels for businesses. Combined with this, we will probably see more challenges raised around the enforceability of flexibility clauses. Unfortunately, I also think there could be a further increase in redundancies with this being a more attractive option potentially, and to avoid the risk of automatic unfair dismissal claims. I appreciate this is all quite a lot to digest and can all seem slightly overwhelming, but the good news is that there is still plenty of time to prepare for these changes before the implementation date. There are a number of steps that can be proactively taken now to prepare for these reforms. So it might sound obvious, but the first thing to do is think ahead and make any required changes prior to the new restrictions coming into force. So consider the imminent and future needs of your business, review existing working practices and any outdated or unprofitable pay and other arrangements. If any associated dismissals are required, it's still likely better to proceed with these now, notwithstanding potential reputational risks with these reforms being on the near horizon. Next, review your current contracts and contractual policies and understand what they say about things like shift patterns. It will also be important to understand what contractual expenses and benefits clauses exist. If there is an opportunity to update contracts now, try to include more discretionary wording, particularly in relation to pay, to reduce the scope of contractual commitments as far as possible. It's something that I've already touched upon, but it will also be really important to include an express flexibility clause in contracts for new hires, and if possible for any existing employees. Just to mention, flexibility clauses do have limitations under case law, but they will ensure employers are best placed in terms of ensuring that they're drafted as widely and as effectively as possible, focusing on key contractual areas. In addition to this, I think it's really important to look to develop methods for implementing changes going forward with a focus on early resolution wherever possible. This will likely involve negotiations and possibly aligning, making any variations at the same time as awarding pay rises. It seems likely that tribunals will also place more emphasis on what steps have been taken to negotiate and incentivise an employee prior to any dismissal. So this should also be relevant to any subsequent litigation. Connected with this, I think it's a good time now to train managers on fair and compliant change management practices. And finally, it's worth keeping an eye out for the outcome of the consultation ending on the 1st of April as to any further updates made around this reform, and in particular, any changes to the intended restricted variations. And so I hope you found that helpful, and many thanks for your time.
Okay, that's great. Thank you so much, Lisa. We've had two questions in the Q&A box. We'll try to, we'll cover these at the end of the webinar. If we can't cover them, we will definitely email you the answers within 24 hours. So just thought I'd flag those, and Lisa and Susanna as well, if you could take a look, if you can answer them at the end, let me know. And just before we get to the Q&A section at the end, just passing on to Harriet, who's going to speak to you about the new laws relating to sexual harassment. So over to you, Harriet.
Thank you very much, Dean. So yeah, a bit of a change in topic now. So the 2025 Act introduces three important rights and obligations this year in relation to harassment. So I'm going to go through each of them briefly. So the first one that Dean mentioned at the beginning, it strengthens protections for workers who blow the whistle on sexual harassment, and that comes in on the 6th of April. The second one is that it requires employers to take all reasonable steps to prevent sexual harassment of their employees. So at the moment, the duty that came in October 2024 was to take reasonable steps. And now they're adding in all reasonable steps. So there'll be a little bit of a change there. And then the other one, importantly, is introducing an obligation on employers to not permit the harassment of their employees by third parties. And that comes in October 2026 as well. So looking firstly at sexual harassment and whistleblowing. So as a reminder, whistleblowing is when a worker raises a concern about wrongdoing in the public interest. And for the worker to be protected, they must reasonably believe that a disclosure that they make is about one or more categories of wrongdoing, which is listed in the Employment Rights Act. And they include about a criminal offence, a breach of a legal obligation, or danger to health and safety, and also that their disclosure is in the public interest. So from 6th of April, sexual harassment is going to be added to that list. So previously, a worker who had suffered sexual harassment and wanted to ensure that they were protected under whistleblowing legislation would have to claim that their disclosure fell within one of the existing categories, often a breach of a legal obligation, so breach of the Equality Act, which obviously made it harder sometimes to fall within the whistleblowing legislation. So from 6th of April, if they sort of blow the whistle on sexual harassment, they will be able to benefit from whistleblowing protection. So against detriment for blowing the whistle and unfair dismissal. So if they were then dismissed, it would be an automatic unfair dismissal on the basis that they'd made a protected disclosure, obviously if that was the reason for it. And with whistleblowing, it doesn't matter when the issue you're complaining about took place. So with an instance of sexual harassment, it could be that sexual harassment that has occurred, that is occurring or is likely to occur. And the public interest side of that generally means that the wrongdoing has got to impact others, not just the worker. So, for example, other colleagues or the public, which might be tricky depending on the circumstances. Tribunal will also sort of consider other factors, often such as sort of the nature and the impact of the wrongdoing, the identity of the wrongdoer, etc. So I think this change does provide some clarity. I think it may also encourage workers to speak up about sexual harassment, which they can show is in the public interest, by using whistleblowing routes, which obviously may include a dedicated whistleblowing hotline if one exists in the workplace, so rather than just raising a grievance about it, which is obviously what they would have to do at the present time. So that may then have a knock-on effect in terms of how employers are going to investigate sexual harassment complaints. And obviously that's then going to fall within the scope of whistleblowing policies. And another change, it would also enable those, if they feel unable to raise concerns with their employer, that they could potentially report their concerns to the Equality and Human Rights Commission or their MP, as they're allowed to do that under the whistleblowing legislation. So, given the time, I will move on now to the other two changes. So the first one to look at is introducing this extra concept of all reasonable steps to prevent sexual harassment. So as you'll know, the Equality Act currently requires employers to take reasonable steps to prevent sexual harassment of their employees during the course of their employment. That came into force in October 2024. The change that the 2025 Act is making is to amend this existing duty to take all reasonable steps to prevent sexual harassment. And this is then going to mirror the existing concept of the all reasonable steps defence in Section 109 of the Equality Act. So this is the existing statutory defence, which an employer can use against having vicarious liability for the actions of their employers. And obviously this could be used in a sexual harassment claim or other discrimination claims. So this is the reason that the law is being changed in relation to the duty to prevent sexual harassment, so that it effectively is consistent with the reasonable steps defence. So there's no confusion or a perception that the threshold is lower for sexual harassment than for other forms of harassment. Employers are also going to be under a duty to take all reasonable steps to prevent third-party harassment under Section 26 of the Equality Act, and that is relevant to all protected characteristics. And I'll talk about that a little bit more after this section. So just a reminder, with the duty to take all reasonable steps to prevent sexual harassment, an individual still won't be able to make a standalone claim for the breach of that duty. So they still need to bring a claim against their employer for sexual harassment to an employment tribunal. So then it's only if they are successful and they're awarded compensation that a breach of this preventative duty will automatically then be looked at. So if the tribunal finds that there is a breach of the Equality Act which involved to any extent sexual harassment, that can then lead to an uplift in compensation by up to 25%. And an individual can also bring a standalone complaint to the Equality and Human Rights Commission under their existing enforcement powers. So what will constitute all reasonable steps is going to depend on the specific circumstances of the employer, so such as their size, the sector, the working environment, the employer's resources, and other relevant factors. Interestingly, the government is going to have power, or has power, to specify in regulations what will be regarded as the reasonable steps an employer should take. These regulations are not expected to come into force until 2027 or 2028 after consultation. So obviously, employers will be needing to review what they already have in place and look at whether that can be improved upon before this comes into force. And these regulations, I understand, will be looking at things like the things employers are already thinking of, but carrying out risk assessments, publishing action plans and sexual harassment policies, and looking at steps relating to the reporting of sexual harassment and the handling of complaints. So once these regulations do come into force, an employer that wants to show that it has taken all reasonable steps will have to have taken the steps in the regulations, as well as anything else that it would have been reasonable to take. Now, obviously, we don't yet have any regulations that tell us what those steps are, but what we do have is what we've had since 2024, which is the non-statutory guidance from the EHRC in its technical guidance, and there's also the 8-step guide that they have to preventing sexual harassment at work. So this was last updated in September 2024, just before the current duty to take reasonable steps came into force, but it's still a very, very useful guide for employers. And the technical guidance also contains guidance on meeting the all reasonable steps defence under Section 109 of the Equality Act. And as a reminder, this 8-step guide looks at areas such as conducting robust risk assessments, having clear policies and procedures, looking at staff engagement and communication, having multiple reporting mechanisms, having effective training and awareness, monitoring and evaluation, and tackling third-party harassment. We did a webinar on this duty in November 2024, which you can find on our website under news and events, and this discusses this EHRC guidance in more detail, so it might be a good one to look back at. So the duty to take all reasonable steps to prevent sexual harassment of employees, including by third parties, is going to be quite onerous. With this extra "all" in there, it is going to be harder to successfully defend a sexual harassment claim. And you've got that potential sort of financial penalty of the uplift if somebody is successful in a claim, and also potential investigation by EHRC. But there was a very helpful case last year on the statutory defence, which I'll cover just at the end, which shows that it can be successful in some cases. So lastly, just moving on now to harassment by third parties. So the 2025 Act is going to reintroduce this liability for third-party harassment, which, as I said, is in relation to all relevant protected characteristics. It's not just sexual harassment. So the Equality Act is going to be amended so that in addition to an employer being prohibited from harassing their own employees or job applicants, they must also not permit a third party to harass their employees. We did previously have a law relating to third-party harassment, but that was repealed in 2013. So it's being brought back after a long period and is quite different in nature. So the new obligation, or the wording of the obligation, is to not permit a third party to harass one of the employees. And an employer will have permitted this harassment if the third party harasses the employee in the course of their employment with the employer, and the employer has failed to take all reasonable steps to prevent this harassment. And a third party is basically going to mean someone who is not the employer or a colleague. So it will include, for example, customers, clients, service users, contractors, visitors, and members of the public. And it has to be harassment related to a protected characteristic under Section 26 of the Equality Act. So age, disability, gender reassignment, race, religion or belief, sex, sexual orientation, and obviously covers sexual harassment as well. So as is the case currently, if you're looking at harassment under Section 26, conduct that's trivial or causes minor offence isn't going to meet the definition of harassment. So that sort of definition of what does harassment mean is not changing in itself. The conduct still has to have the purpose or effect of creating an intimidating, hostile, degrading, humiliating or offensive environment for the complainant, or violating their dignity. That's the definition under Section 26. And in order to meet this test, where that was the effect of the conduct but wasn't its purpose, it's not enough for the individual to sort of perceive that someone's conduct is offensive, that they were upset. The tribunal has also got to consider whether it was reasonable for the conduct to have that effect. So it's an objective test where the particular facts have always got to be considered. Now, an important point here really is about balancing these rights on a particular case with the right to freedom of expression under the European Convention on Human Rights, which is Article 10. So that's the right to hold opinions and to receive and impart information and ideas. So as a result, the measure that's coming in isn't going to mean that employers are required to take steps to prevent employees ever being subjected to conduct that they might regard as offensive. It's only required to take steps that are reasonable to prevent this sort of legally defined harassment. So not every unpleasant comment by a customer, for example, is going to amount to harassment. And obviously you may have situations where a third party is engaging in some sort of political debate, or people will express their views in a forthright manner. Employers can't always obviously prevent that, and they're not going to be expected to. And obviously remember that the conduct has got to be related to a protected characteristic, not just be generally offensive. But obviously, if an employer operates in a sector where their staff frequently come into contact with third parties, hospitality and retail is obviously the most sort of obvious one, this duty to take all reasonable steps to prevent third party harassment is going to be particularly difficult to meet. Employers obviously have far less control over the actions of third parties than they have over their employees. But the government has stated that the expectations on employers in respect of preventing third party harassment will be lower than those on preventing harassment of their own employees. And you will still have this statutory defence to show that the employer took all reasonable steps to prevent that harassment. As I mentioned earlier, there was a helpful EAT judgment last year in which unusually the statutory defence was successfully run, and this was a race discrimination claim. And it is quite notable because often the statutory defence isn't even run because it's quite difficult to meet, and if it's run, it often fails because there's always something else an employer could have done. So this case was Campbell and Sheffield Teaching Hospitals NHS Foundation Trust, and it provides helpful guidance on the tests that a tribunal should apply. Firstly, looking at what steps were taken, and secondly, looking at were there any further steps that were reasonably practicable and the respondent should have taken. And in this particular case, the employer had done enough to prove the defence. And here it was particularly relevant that the mandatory equality and diversity training had been delivered days just before the incident complained about, which is obviously fortuitous. And the expectations about behaviour were regularly reinforced, which is really important, via policies, had posters around and appraisal meetings. But this does highlight the importance if you've got to implement these things in the first place and then continuously reinforce comprehensive measures to sort of prevent the harassment. And you can see from this case that doing so means that it might be possible to rely on that statutory defence. So I think just to sort of summarise, it's really important, obvious as an employer, ideally you've already got something in place to comply with this sort of current duty to take reasonable steps, but with the extra onus on all reasonable steps, I would advise that you review what you have in place now. Make sure that your policies on harassment and dignity at work do include third-party harassment. Make sure that training is delivered and it's regularly reinforced or repeated, and obviously keeping records of this. As Susanna mentioned, I think ensuring this is covered specifically with new starters in induction is particularly important, because obviously if you did some training 6 months ago, they've missed that training, and depending on how regularly it's repeated, it may be that you have new starters who aren't getting any training. So that needs to be borne in mind as well. And I think lastly, just particularly with third-party harassment, consider whether displaying notices that harassment won't be tolerated would be appropriate. Always taking swift action when incidents are reported, and document the steps that are taken. And I think particularly conducting risk assessment for customer-facing roles is going to be particularly important. And I shall pause there because I see we've only got a few minutes left. So back to Dean.
We do. Thanks so much, Harriet. Yeah, and 4 minutes left. So we do have some questions. I think I could answer them, but obviously feel free to chip in as well, everybody else. First question, I'll go for an easy one first. So from an anonymous attendee, do employers have to put benefits in the employment contract? The answer to that is yes, that's a requirement for employees after 2020 via an amendment to the old Employment Rights Act, the Employment Rights Act 1996. So yes, you do need to include benefits in the contract. Question from Claire, who's so I'm just reading the question on a different screen. You mentioned reasonable adjustments, disability being raised much, when performance concerns are being addressed, and the need to address adjustments at recruitment stage. do you envisage any change in candidates being encouraged to share disability needs? And it was Claire's understanding that employers were not allowed to ask, essentially. Does anybody else have an answer to that, or would you like me to kind of go ahead with it?
You go ahead, and then I can follow up if I don't think you cover it all.
I've just whilst I'm here, just sort of looking at the ACAS guidance for this, and employers are allowed to ask questions. I've just got it on my phone here. Employers are allowed to ask questions about disability at the recruitment stage, to find out if it's necessary to make reasonable adjustments for the recruitment process, but also after that, if when the person starts the job, whether reasonable adjustments are necessary, to allow them to do the essential parts of the job. Of course, candidates can disclose disabilities voluntarily should they wish to as well. So you're generally not allowed to ask questions about disability, but provided one of the exceptions is used, then you are able to do that as well. So in that regard, I think, as you said, Susanna, the first 6 months of employment are now so critical. And people who aren't performing, you may find, more stress-related issues, disability points being raised. And provided this is done in the right way, put my neck on the block here, I think you can ask the right questions during the recruitment stage, provided it's done with the right intentions to sort of flesh out whether someone has a disability and if adjustments are made. And also the rules are different. Once you've made that job offer to somebody, you are then in a better position to ask questions about disability. So that's my view. Did you want to add?
Yeah, I think the duty also, though, extends to employers when they're looking at, when they're recruiting, that any of their criteria that they're using to recruit, they need to just check that doesn't constitute a practice provisional criteria that might disadvantage individuals with disabilities. So I just think that we're going to see potentially more people with disabilities and or protected characteristics who might challenge employers now at this early recruitment stage, because I expect that most employers are going to tighten up their recruitment substantially because of the new rule about 6 months and acquiring unfair dismissal rights.
Okay, great, thanks. And the dying moment, we did have a question before the webinar from Catherine, who asked about overviews and timetables. As I mentioned earlier, on our website, joneschase.com, in the news and events section, we do have a more comprehensive guide on the Employment Rights Act, so please have a look at that. We're going to be releasing a lot of stuff about this. We've got a forthcoming timetable as well that will be released on the website, and we'll have email bulletins of explaining when certain parts of the Act are coming into effect. So thanks for the interest in that, Catherine. Two final quick questions here from one from Tasman, which is a question about 0 hours contract, and they have associates and contractors who, some of them work on using their own personal service companies, others are presumably just sort of self-employed and are consultants. The question is whether there was any obligation to now place contractors or consultants onto a full-time employment contract if they're on the 0 hours contract. My understanding of that is currently is no, and under the new law, I don't think that would be an obligation either. We will double check. Well, actually, Susanna's shaking her head as well. So yeah, I didn't think it was great. So that's a no. Hopefully that's helpful. And then just finally, a quick question from Naomi, who's asking, are any sectors exempt from the third-party harassment changes?
Not so far as I'm aware at the present time. I believe there are no exemptions. That's my understanding.
Okay, thanks so much, Harriet. That is the end of the webinar. We all really appreciate you attending. Thank you so much. As I mentioned earlier, we've got plenty of information forthcoming about the Employment Rights Act. We do have a detailed Employment Rights Act compliance package that we're going to be releasing over the next couple of months to help our clients really get on top of the law and to have a considerable business advantage against those that don't. So more details on that to come, and all that's required in the meantime is to say thanks so much for attending, and we look forward to seeing you on the next webinar. Okay, take care. Thank you. Bye-bye.